Hi, my name's Sharon Donovan. I'm an attorney in Salt Lake and have been a family law lawyer for, almost 30 years or so. I specialize in family law, and the Young Lawyers Division asked that I present some information regarding some tips for family law lawyers that might be helpful to the new practitioner. So I've tried to go through my little checklist to think back when I was a lawyer and what was helpful or might have been helpful for me. So I've kind of organized my thoughts in that fashion and not in any particular order. I remember when I was a brand new baby lawyer many years ago, I worked for Utah Legal Services up in Ogden, and I remember that my very first week of work I had to be in court. And of course, we all know that once you get out of law school, you really don't know how to be a lawyer. And I knew some of the family law concepts, and I knew where the courthouse was, but I didn't know anything else about how to present a court case to the court. So over the weekend, I fretted and I thought, well, I need some help on this. So I called my brother, who was a couple years older and was a lawyer, and said, oh my gosh, what do I do? And he said, Sharon, get your legal pad out and write this down. You say who you are, who you represent, what the issues are, and then he went through a little laundry list of what I needed to talk about. And so I thought, well, that's a good start. And so I showed up at court against the divorce king of Ogden, Pete Velakis. Hello, Pete, if anyone in your firm is reviewing this tape. And I was very nervous. And of course, we went in the back room, had a little discussion about the issues in the jury room, and Pete could not have been more gracious, knowing that I was a brand new lawyer, not knowing anything what I was doing. And we ended up stipulating to the issues, and was very relieved that I didn't have to present some long argument to the court. Now, the next time I had to do an order to show cause hearing, then it was much easier. And what I learned as a new lawyer was that it is helpful to ask other lawyers whom you trust and whose style you appreciate and would like to emulate for a little bit of help whenever you're doing anything that you don't know what you're doing or you don't feel comfortable doing. In terms of the court process itself, I think being a new lawyer, it is important to get a feel for the court system. And basically what you need to learn is to know the people that can help you. Obviously, if you're before a court commissioner in a domestic matter, which is pretty much everywhere in our state system except maybe in the rural areas, you get to know who the clerks for the commissioners are. You get to know the commissioners themselves and their preferences. You get to know the judges and their preferences, and if you don't know those preferences, you learn their clerks' names and you treat them with respect and ask them questions. They are more than willing to help you learn this process. So not only do you need to know the players involved, you need to know the other lawyers, get a sense of what those lawyers are like, and don't be afraid to ask questions. What you learn with lawyers is that they love to talk. They are paid to talk, and they would be more than happy if you act a little naive rather than overbearing to answer any questions you have. And I think that the biggest mistake that young lawyers make is by acting like they know everything and coming off very bombastic, kind of a know-it-all, and that really does not play well with anybody. I think being a little bit circumspect and gracious, ask some questions, I think that that's a much better way to help you through the process. The other thing that you will learn as a new lawyer is that you may have to deal with pro se litigants. And that's a whole process unto itself. And if you have some questions about that, be sure and ask someone. The other thing that I found helpful as a new lawyer, and I would recommend to you, would be to go watch the court process. If you have a hearing before one of the commissioners, go sit in on one of the commissioners' calendars. if you have a hearing or a trial before one of the judges, go sit in on one of those proceedings, because you can learn a lot about the way people do things that you like, the way things that are done that you don't like, what sort of style you like or don't like, and pick a style that fits your personality and is something that you think works well with the court. Some of the procedural issues that you should be aware of would be the motion practice before the commissioners and also any motion practice before the judge. You will learn that under Rule 101 of our rules, that is the procedure that is outlined for motion practice before the commissioners. You should be aware that effective November 1, 2005, those rules were changed, and the time frames within which to file matters with the court is really important, and you need to file things sooner than you otherwise had to file them. The reason for that is so that the other side has notice of what your argument's going to be, as well as the court, and gives the opposing party time to deal with the motion or issues at hand and to respond to those issues in a timely fashion, rather than the previous practice of receiving a 3-inch stack of papers at 5 o'clock the night before a 9 o'clock a.m. hearing, which was not helpful to anyone. The courts are, as I understand it, abiding by these rules quite carefully, and I'm sure that these rules will be modified over time, so make sure you're up to date on what the current rules are. The other thing that's very important is under the new rules, any attachments that you intend to file, such as financial information, child support worksheets, any other attachments need to be filed with your initial filing. And if there are some income issues, alimony issues, other issues, the court requires that a financial declaration be filed at the time of the initial pleadings. If there's child support that's involved, you need to file a child support worksheet at that time. And the courts are becoming very strict on these rules. They want everything attached at the time of the initial filing. And so what we're doing in our office, in any motions for temporary support, temporary custody, we are filing a financial declaration and all of the attachments with the first filing, together with a child support worksheet. You should be aware that there is a procedure for courtesy copies to the commissioner. That is a very important process. The commissioners want courtesy copies before the hearing so they have an opportunity to review the issues at hand and be prepared. You need to know your judges to determine if you have a hearing before the judge, whether the judge wants courtesy copies or not. There are a few, such as Judge Tim Hansen, that I don't think wants courtesy copies. But again, that's something that you ought to talk with the clerk and find out the preference. But if it's before the commissioner, file your courtesy copies several days before the hearing. And if you do not meet this new rule on deadlines, the court can either hold the hearing and decide to make rulings later, or can continue the hearing and also award attorney's fees for not complying with the rule. So I would urge you to make sure you are very aware of this rule and the deadlines. Likewise, if you want affirmative relief in your motion, you can't just respond and say, oh, by the way, I want custody of the children. You need to file an affirmative counter motion. Otherwise, the court will not entertain your motion for affirmative relief. The other procedural issue you should be aware of is that if there are contempt issues, violations of court orders, those sorts of things, that needs to be done by way of order to show cause rather than by motion. There are certain matters that the judges will hear under Rule 101 that you should refer to the rule. It would be such as motions to waive 90-day waiting periods, motion for entry of default judgment, and other related matters. So just read the rule and make sure you're up to speed on that. In terms of case management orders, you should be aware of the new discovery rules on case management orders and meet with opposing counsel or have a telephone conference with opposing counsel prior to really getting going on your discovery in this case. And that's a very good way for you to meet with counsel and informally discuss the issues. The other things that you should be aware of is the fact that there are a lot of lawyers out there that would be happy to mentor you if you have questions. There are American Academy of Matrimonial Lawyers that you can contact, and their names are known by the Academy in Utah, as well as members of the Family Law Section, the Executive Committee of the Family Law Section, and such. The other category of issues that you should be aware of would be our new Utah Standards of Professionalism and Civility, which were adopted by our Utah Supreme Court in October of 2003. The purpose of these rules is to provide personal courtesy and professional dignity to the courts, to counsel, to non-parties, and to everyone involved in the proceedings. I would urge you to review these rules as these are being followed by the courts in terms of what civility is expected by counsel in any case before the court. The whole theory behind these rules is that the rule of law is a foundation for a just and peaceful society, and how we treat others and how we are treated by the court just lends civility to our whole being and our system. There's provisions in the professionalism and civility rules dealing with scheduling, courtesies for continuances, and those sorts of things, how to educate clients to handle themselves in their action, in my cases, divorce cases, and how you should not engage in ex parte communication with the court. One of my pet peeves is I think that lawyers have a duty to educate not only other lawyers, but also their clients as to how they should be behaving in their own case. The other sort of pet peeve that I have is how to act in court. And I think particularly for new lawyers this is very important. New lawyers typically haven't been in court. They don't really know how to act. And I have a couple of little tidbits that I've shared in other family law seminars, and I've kind of compiled a list, and let me share a few of those with you. Number one, always endeavor to take the high road. The view is better, you meet some nice people along the way, and you feel much better about yourself when you arrive at your destination. The second one, treat your opponent as professional and worthy, even if you don't like them. Sometimes you must remind your client, and on occasion yourself, that you are only a lawyer, not a magician. Likewise, in terms of judgment, good judgment, this is one from Mark Twain, good judgment comes from experience. Experience comes from bad judgment. A lawsuit is like a pancake. No matter how thin you pour it, there are always two sides. Those are some things that I think are really important. And this, some judges use this phrase. Some people may think it has a religious connotation, but this applies to lawyers, non-lawyers, the court system, the clerks. We should always treat each other and other parties with the golden rule. You treat others as you would like to be treated. And this is something that really we should live by. We should consider out-of-court settlements rather than litigation. And in light of that, we have mandatory mediation in Utah, statewide, in all domestic cases, and which is a really good thing. The exception for that would be a spouse abuse case. And so I would urge you to learn the mediation process, get to know the mediators, maybe even take the mediation training through the bar. It's a great training, and I think that's where we're going in family law disputes, and I think other alternative dispute resolution and other civil cases. In terms of other alternative dispute processes, there's the Collaborative Family Law of Utah. It's a cooperative settlement type of concept like mediation. And I'm going to give you the website. You might want to get yourself familiar with this organization, which is fairly new but very active. collaborativefamilylawofutah.com. One of my other pet peeves for young lawyers, and this applies to women and men alike, is dressing like a lawyer. I think the younger lawyers probably are used to being a little bit more casual. Pants have become a little bit more the accepted norm for women. I would ask you to think about the judge on your case. A lot of the judges are still old establishment lawyers. There are some judges in district court. I would never wear pants to a court. I would never wear pants in federal court. And again, everybody has their own style, but just keep in mind who your audience is. And I would dress like a lawyer. That also applies to men. You should wear a suit and tie. You should look like a lawyer. You should act like a lawyer. The other issue that I have as it relates to women lawyers is because I was one of the few women lawyers there were when I started practicing law. I think when I practiced in Ogden, there were two. And I remember one time I had presented a case and lost a case up in Davis County, and the old establishment judge wanted to see me back in his chambers after the court. And I thought, oh my gosh, I must have done something wrong. And I went back there. He introduced himself. He was a very religious member of our judiciary. And he complimented me on doing a good job in his court, although I lost the case. And he said, most women lawyers try and come in and act like men, and they try and be overly zealous, and people should be who they are, and it just does not work well. And again, whether you're female or male, don't try and be someone you're not. Try and be true to yourself and go with the style that works best for you. An overbearing, scorch the earth type of lawyer does not work well for anyone. The judges hate lawyers who argue with each other, come in, are bombastic, try and embarrass people. It just doesn't play well at all. And lastly, I think you just remember who you are and what you stand for. And again, be true to yourself, and you can be a very good advocate without being a jerk.